Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. Hey, today I wanted to talk to you about some protections specifically against changes with the rating schedule. So in other words, there's been talk off and on from the VA about, and they have changed the rating schedule in the past. Some of the most recent ones that they've been talking about doing but have not implemented yet was eliminating the tinnitus rating as a actual condition to be rated and use tinnitus as a sign or symptom of another condition. And another one they talked about was sleep apnea at 50% with a CPAP, changing those criteria and drastically lowering that. So what happens to those of us that are already rated at certain levels for certain conditions and where we fall squarely where we're supposed to be, and the VA changes the ratings for that? Are we going to get re-examined? Are we going to have to go back and potentially get a reduction in our rating? What can we do to protect ourselves? Are we going to be grandfathered in? All of those things. So I'm going to dive into that and let you know what the VA's laws that they're governed by tell them, the VA, to do in those types of situations. So please hit the thumbs up for me. Subscribe if you haven't. I really appreciate it. We need to continue growing this channel so that way we can get the reach wider and get this information into the hands of those of us that need it, right? So with that, let's jump into it here. I pulled up some information on the VA and specifically this topic, right? And I wanted to talk about it because I feel as though it's really important to make sure that we are all on the same page. Now, with regard to this, I'm pulling up all right. So this is essentially it's the Code of Federal Regulations, and it's 3.951. This is inside, it's basically kind of like their operating procedures, right? It's what they look to and follow and what governs them. Now, do they do it right all the time? No. But let's read what they're supposed to do, okay? So, all right. This is under Section 8, and it's item G, or whatever you want to call it, protection against rating schedule changes. Public Law 102/86 states that a rating evaluation cannot be reduced solely because of a change to the rating schedule subsequent to August 13th, 1991. However, 38 CFR, Code of Federal Regulations 3.952, protects rating evaluations under the 1925 rating schedule, which were the basis of compensation on April 1st, 1946. So for those of you that know the Washington Post fiasco and the Congressional Budget Office ludicrous recommendation, some of the legs that they're trying to stand up under this is that this rating schedule was essentially adopted in 46, and that is what's really being used for us. Now, there's been some changes, but they want to totally revamp this. So that's what prompted me to dig into this a little bit for you. So it says here, note, evaluations in effect evaluations in effect when previous changes to the 1945 rating schedule occurred are not protected by PL 102-86. That means that if you had something happen before 1945, some sort of a change, probably not relevant for any of us. Let's move on. So, reference, for more information on the preservation of disability evaluation after rating schedule changes, see 38 CFR 3.951 alpha and 38 U.S.C. 1155, and I'll dive into those here in a second as well. The next item here, it states still under reviewing evaluations after rating schedule changes. When reviewing, and this is the VA, right? So this is telling the VA what to do. So when the VA is reviewing a disability evaluation after a change in the rating schedule, Determine whether the current evaluation would be continued or decreased under the prior schedule. This is really important because what this is saying here is the VA is supposed to look at the prior rating schedule, and if you have improvements that would have warranted a change on the old rating schedule, that's what they're supposed to use. They can't just go, oh, the new rating schedule reduces you based on where you're at, so we're going to reduce you. No, they're supposed to go, oh, okay, you do so show some signs of improvement potentially. Let's look at the old rating schedule that you were on and see if that would have changed your rating. No, it doesn't change your rating. Okay, you're fine, and they just keep you there if you're in that boat. But that is a level of protection that you need to know about and feel as though there's some sort of level of protection against rating schedule changes. And it's important to know because if they do screw up and change you based on the new rating schedule, you need to know that you can fight it, and you need to know that your fight is a winnable fight because they screwed up. So instead of just it feels like it's wrong and pound your fist, who cares if you feel it is wrong, and here's where and here's why. So you can fight it with actual fact and get it changed and overturned. So moving on, there is a note under that. It says the disability evaluation cannot be reduced unless you, the VA, can show the veteran's condition improved enough to have warranted reduction under the prior schedule. So it's just reiterating what I just said. So that part is that. Let's go over to the other things that they referenced here. So under 3.951 alpha in the Code of Federal Regulations, it says preservation of a disability ratings. Alpha here, it says a readjustment to the schedule of rating disabilities shall not be grounds for reduction of a disability rating in effect on the date of the readjustment unless medical evidence establishes that the disability to be evaluated has actually improved. Now, remember the other one that I just read, which dived a little deeper and said that the improvement has to be compared to the old schedule of ratings, not the new one. So this one doesn't specify in this description here. And that is all of that. It's only 3 lines. So next, they said to look at the 38 U.S. Code 1155. And in here, it's a little bit bigger, and I'm not going to read the whole thing, so I'm going to go down to where they're specifically talking about this. And it says, the Secretary of the VA, the Secretary shall from time to time readjust this schedule of ratings in accordance with experience. However, in no event shall such a readjustment in the rating schedule cause a veteran's disability rating in effect on the effective date of the readjustment to be reduced unless an improvement in the veteran's disability is shown to have occurred. Now, again, I'm going to go back to, and my argument would always go back to that statement in Item 8, protected evaluations under 38 CFR 3.951 and CFR 3.952, and Item G, and down there a little ways it talks about, or Item H, reviewing evaluations after rating schedule changes, where it specifically states the disability evaluation cannot be reduced unless you can show the veteran's condition improved enough to have warranted reduction under the prior schedule. Very important, very, very important. So it's good for you to have some sort of reassurance that you would be protected if they change the schedule. And 2, it's important to know how to combat it if they do screw up and reduced you based on a new schedule. So with that, we'll go ahead and end it there. Thanks so much for watching. I appreciate you. Hit that thumbs up, subscribe, share with a friend, all that good stuff. Let's grow this channel and get this word out to more of us. Thanks again. Have a great one.